Namaskar all. Today we will be going ahead with our journey of internship with new topics, and these topics are of utmost importance to all of us. The reason is it gives the knowledge to the lawyer, which is actually difficult for a litigant person. Now, as the names you have heard, reference, revision, and review. Normally, we hear the words अपील करना है, अपीलत जायचे, ऊपर वाले कोर्ट में चलेंगे, अपील करेंगे. But revision, reference, and review are actually different. And let me tell you, these are the tools for the lawyer to get the best justice for their client if they know the proper meaning of these terms. Now, I will start with the word reference. Now, if you see in all these three words, you see the word is RE, reference, inference, reference, revision, revision, review, review. So it is actually again an exercise by the court and under the legal provision. Now, when you do this, what happens? It actually easier for yourself to get justice for your clients without going into appeal matters, and sometimes you can show to the court that there is a mistake in in this matter and you can correct it, because even the court can make mistakes. So under these three things, even the courts can review, revision, that is revisit, and also make a reference. Now, I will first take the reference. Now, when you speak about the reference, it is like making a reference. I'll give you the best example of the reference. Two best examples, then it will be easier for you to understand. Everybody knows Sabrimala case. Now, Sabrimala case comes under the review petition before the Supreme Court. Now, also there is one more case, that is of the adultery under section 497, which was struck down by the Honorable Supreme Court. Now it is no more an offense, that is adultery is no more an offense under the Indian Penal Code for citizens. But when it came for the army people, armed forces people, that is the army, air force and navy, it is still an offense because of their becoming their conduct is very important, the discipline is important. Now when this matters came before the Supreme Court, whether army personnel can be prosecuted for 497 IPC when it is actually struck down by this Honorable Supreme Court. And this reference was made by Union of India, that is the government, central government, that whether it is actually the army people or the armed forces people can be prosecuted. It said yes. So 497 IPC is actually alive for the armed forces people till date, and they can be prosecuted, charged, and their court martial will be done. So this was a reference for clarity, to bring clarity in act, ordinance, or law. When you speak of the act, ordinance, law, the government wanted clarity whether they can be. The Supreme Court said yes. See, it is a reference by the Honorable Supreme Court. There was also reference in 2G case, and this if the reference goes to the Supreme Court, it is signed by the President of India. It gives the reference by the signature of the under the President of India and says advise. So it's actually advisory jurisdiction of the Supreme Court. Now, when you come to the subordinate courts and the high courts, the reference is different. Suppose there is a court where DV matter comes up, and there is some difficulty on the legal aspect, and the court feels that it should ask the either the if it is a JMFC court or court, Metropolitan Magistrate Court, they may give a ask for a reference to the magistrate will give a reference to the higher court, maybe session court or this is high court, and they will give the actual answer to that, they will adjudicate it and they will answer the reference. So the reference is always by the subordinate court to the higher court on the clarity of some act, law, or any ordinance which is passed. So there are, when there is no clarity on any law, the subordinate court makes the reference. Now this reference is at Supreme Court level. Normally it is through the Supreme Court itself. So moto can also take, because there is some difficulty in interpretation of some law or statute. And when it comes to the High Court, suppose there are two, three High Courts which have different opinion on different matters. It will be, suppose Madhya Pradesh High Court has given a judgment in a DV matter another way. Then it will also, there is a Rajasthan High Court which is speaking in a different adjudicated the matter in a different way, and there is a Bombay High Court. Now there are three high courts which have different opinion or different judgment on a same subject. In such cases also there can be a reference, and the Supreme Court suo moto can decide that this is the right position. So there is no ambiguity in the law in the entire country, and there is certainty of the law. So reference is always for the clarity. Reference is rarely used at the subordinate courts, but there are examples. If you Google or if you go to indianqanun.com or something, you will still file a reference at the high court level and session court level, but very rare thing. Now next is very important part is the review. Now the first thing I want you to register, review is before the same court. Review is not an appeal. Review is before the same court. If you understand for the day only this, the review is before the same court is more than enough. Review is not an appeal. Now see, when I say that review is not an appeal, it means actually that you can bring the error apparent on the face of record, or there is some mistake of evidence or mistake of facts to the court notice, and which will turn the judgment other way around. You cannot bring the small things to the court. Only thing review is before the same court, and only something very important part where the mistake has taken place by the court, then you can ask for the review the order. Now when you check the CPC, review is before the same court, one thing. Secondly, review is always of a civil matters. It is criminal courts are barred from making review of their matter. Now even the high courts cannot review their own civil matters. Civil matters they can review, criminal matters are barred. Their judgments cannot be reviewed, except for some, there is, they can recall it for the arithmetical mistake, or there is some name mistake, something like that. For small mistake it can be. When you go but when you go to the Supreme Court, there can be a review petition for the civil as well as criminal. Supreme Court does not distinguish between civil or criminal review. Now the best example is of, as I said in the beginning, is the Sabrimala case. It is a 9-bench judgment which is again for pending before the review court. Review as and by way of review petition, and I think it is in now posted in April. It will be live stream. If you can see, please do check up. Now when you see the that Supreme Court does not make any difference between civil and criminal review. Now there is a limitation period for review, that is 30 days. Now for reference there cannot be a limitation, but for this review and this again we are going to for revision, there also there is a limitation. For revision it is 90 days. When you say that for Supreme Court that there is no difference, then also 30 days. But can you make an application after 30 days? Yes, you can make. Then you need to explain the delay. If you can't explain that delay, then it is actually very difficult, because court feels that you are not serious. If there is any mistake, you should bring to the court's knowledge immediately. So review is also very important part. Without going in appeal, you can bring the fact to the knowledge of the the same court and the judgment can be turned around if there is a actual some mistake by the honorable court. Sabrimala case is pending under the review petition now again, even after the final judgment. Now next we go to the revision. Now revision is like revisiting. Now revision is not before same court. Revision is will always be to before the higher court. Now revision powers are with the session court and the high court. Now what happens? There is some order. It may be interlocutor. It is not a final order. See, there is a difference between revision and appeal. When the matter is pending before the subordinate court, it is not finalized and you are aggrieved by some reason that the order is not in your favor and there is some apparent mistake, there is some error, there is some jurisdictional error which or there is legality which you want to challenge, then you need to file a revision before the higher court. It may be a session court, high court. When you file a revision there, if the court passes an order in your favor, the matter comes remanded back to the subordinate court, and again the order is in your favor, and you can restart the matter from the place where it has left. Now, one thing about revision, you have to remember the revision is never against the final order when the matter is pending. But review can be against the interlocutory orders also, and against the final orders also. But review is always before the same court. So this is difference between the review, revision, and the reference. Reference is very rarely used by lawyers, but revision review are regular tools. As a lawyer, you can use those and get justice for a client. For every review and for every revision, there is a reason which you should bring to the court's knowledge. If it is a small spelling mistake, or there is a instead of 20,000 it is written 2 lakhs, it will not be a bigger thing. The arithmetic error, it can be corrected. But in the criminal matter, there is no review. So this was all for today on the academic side. Now I will move towards the next chapter, that is of judgment reading. सुजी को ये कर दीजिए आप. Just a minute, Suji. Can you check?
No, the screen is coming up. It is visible now.
Yes, you can start now.
Madhya Pradesh High Court, Chotalal Patel was the state of Madhya Pradesh on 2nd April 2012. Applicant has preferred this revision petition under section 397 by 401 of the Code of Criminal Procedure being aggrieved by the order dated 13/9/2011, passed by the learned special judge, Scheduled Caste and Scheduled Tribes, Prevention of the Atrocities Act, whereby charges under section 347, 148, 307, 1049, 332, 149, 294, 427 of Indian Penal Code and Section 3, subsection 1x of the Scheduled Caste and Scheduled Tribes Prevention of Atrocity Act were framed against the applicant along with other co-accused persons. Second, facts in short giving rise to these petitions are that on 11th July 2010 at about 14:30 hours, complainant Ashok Kumar Patwari of Halka number 52, carrying out the order of Raj Kumar Khare, revenue inspector, in regard to deliver the possession of Khasara number 841, Rakba 1.047 hectare to one Saraswati Bai. For this purpose, he took the aid of police force in which Head Constable Hanif Khan and Constable Nizam Singh were also present there. Other persons, namely Saraswati Bai, Damu Ahiwar, Hariram Ahirwar, Kotwar Santosh Bhadrana, and Gorilal were also present there. It is further alleged that when complainant performing the duties as a public servant, applicant along with the other nine co-accused person came there to deter them from performing their duties, and when Constable Nizam tried to intercept the accused person, the co-accused Bihari assaulted him by means of a sharp weapons, katana, with an intention to kill him. Thereby, Bihari sustained injury on his head. Co-accused Bihari again assaulted Nizam by the way of Katana. He received injury on his pinna. Thereafter, he fell down. Applicant and the co-accused person assaulted the head constable Mohammed Hanif and Kotwar. It is further alleged that all accused persons broken the motorcycles of complainant and police force, destroyed the revenue record of the complainant, and fled away from the spot. The report was lodged and police forced by the complainant Ashok Kumar Patwari on same day at 15:10 hours at police station Banda, district Sagar. Crime was registered against the accused person under section 147, 148, 149, 307, 353, 332, 294, 427 of the IPC and section 3 subsection 25 of Atrocity Act. After usual investigation, applicant along with other co-accused have been charged sheeted before the learned special judge atrocities. On appraisal of first information report, charge sheet and other material on record frame the charges against the applicant and other his co-accused persons as mentioned herein above. Fifth, learned counsel appearing on behalf of the applicant submitted the trial court committed illegally in framing the charges, especially under Section 307 of the Indian Penal Code on the basis of material placed on record. He further submitted that even on taking the face value of FIR MLC reports, it could not be deemed fair that applicant or any of the co-accused has committed the alleged act with an intention to cause death of any victims. It is further submitted that co-accused has committed all alleged act with an intention to cause death of any victims. It is further submitted that co-accused has committed alleged act in intention to cause death of any victim. It is further submitted that statements recorded under section 161 of the Code of Criminal Procedure are not disclosing any ingredients in regards to the charge under section 307 of IPC. It is further submitted that at the most case may come under purview of section 332 of the IPC. He placed reliance on ILR 20121 MP 2601. Kanhaiya Lal and others were state of Madhya Pradesh. 6. On the other hand, learned public prosecutor for the state justice justified and supported the impulsion and other passed by the learned trial court and submitted the intentions of commit under cannot be gathered unless from the injury reports. It is further submitted that if witnesses stated that applicant or his co-accused assaulted the injured person with an intention to kill him, then it is sufficient to frame the charge under section 307 of the IPC. Therefore, he praised for dismissal of the revision petition. 7. I have heard the learned counsel appearing on behalf of the parties and pursued the entire charge sheet along the impurging order and charges framed by the trial court. Eight. It is undisputed that complainant Ashok Kumar went on the spot along with police force to discharge his official duties for having over the possession of Saraswati Bai. 9. From perusal of statements recorded under section 161 of CRPC of Ashok Kumar, complainant and independent witness, Hale had injured Mohammed Hanif, it reveals that all of them stated the applicant came on the spot along with other co-accused persons with deadly weapons, namely lathis and katana, and tried to deter the public servant from performing his duties. When Nizam and Hanif, member of the police force, intercepted them, the co-accused Bihari assaulted them by the way of katana with an intention to kill. He gave first blow on his head and second blow on his ear. MLC report of Nizam revealed that he got an incised wound of 6 centimeter into 0.5 cm and deep bone on left side of occipital region and another last wound around left ear pinna and two more contusion. It further reveals that doctor opinion that inside wound may have caused by hard and blunt object and advice for repair of the pinna by ENT surgeon. It is also on record that other victim, head constable Mohammed Hanif, and sustained as many as 8 injuries, some of the contusion and some of the abrasions. Complainant Ashok Kumar Patwari also sustained as many as 4 injuries, out of which two are contusion and two are abrasions. Witness Hale also sustained an incised wound and an abrasion. Sitaram sustained as many 6 injuries, out of them some of the contusion and some of the lacerated wounds. All these MLC reports, along with the statements recorded under Section 161 of CRPC prime facie, show that applicant along with co-accused assaulted the complainant and other injured person and deter them from performing their public servant duties. It further reveals that two persons got incised wound, which shows thereby weapons, namely katana, was used. It is also on record that Nizam got more than one injury on the vital part of his body, like head and ear, which shows that it is a repeated blow on his vital part, with an intention to attempt commit his murder. In these circumstances, fact of the case in hand is different to the fact of Kanhaiya Lal's case, Supra. In that case, there was no incised wound caused by sharp weapon, and statements recorded under Section 161 of CRPC were also not supportive in regard of the offence, Section 307 of IPC. 10. In these circumstances, I am on the view that trial court has not committed an illegality or irregularity in framing the charges against the applicant. Therefore, present petition has no force liable to dismiss and is hereby dismissed.
See, this was from Madhya Pradesh High Court, and I'm showing something. It's a criminal revision. See, it's a criminal revision. So you can file in the High Court. This was the reason to read this judgment. Now one more judgment. Wait. You have to begin.
Visible.
Wait. You have to begin. Good. Thank you. You have to start. This is from Karnataka High Court. And as you can see here, it is review petition, right? Okay. I thought it will benefit all of us if we revise with the help of the judgment. This is a little longer, but let me see how much we can complete. You can start from the point number 2.
Since these review petitions are arising out of division of the property of original prostitute, yes, Mangesh Rao and the parties to review petitions claiming succession under the original ma'am, how do you pronounce that? Propositus.
Propositors, you can say like that.
Propositus. Mangesh Rao, the review petitions were heard together and disposed of by the common order. In RPN number 10088 by 2014, it is the contention of the petitioner that this court, without considering the rights of the petitioner and based on the finding rendered in RFA NC 2025 of KHC D 326,
skip the numbers.
Passed the impugnant order without considering the grounds.
Impugned order.
Impugn order without considering the grounds urged in regular second appeal. It is also stated that opportunity has not been extended to the petitioner to put forth his case. It is also stated that petitions that review petitioners has purchased the scheduled property from its owner, wherein the rights of the vendor has been protected by allotting share in the suit scheduled property, and the same has been confirmed under and according sought for interferences to the court. It is contended in the review petition that this court has not considered the judgment of Honorable Supreme Court in case of Kunyamed and others were State of Kerala and other reported in AIR 2000 SC 2587 with regards to the implication of Section 3, subsection 2 of Hindu Women's Right to Property Act, therefore sought for review of the impurgent order NC 2. Okay. In RPN number, the review petition has contended the respondent number 3, Abdul Qasim, has purchased item number 4 of the scheduled property in SY number 476, measuring 014 guntas, which includes the constructed portion as per the registered sale deed dated 23/10/1981. Respondent number 3 is a bona fide purchaser for a valuable consideration, and as the suit is filed by plaintiff, has been dismissed by the trial court and later confirmed by the first appellate court, and in the view of the matter of finding recorded by the court in the impurgent order is incorrect. It is further stated that the plaintiff is not entitled for any share in the property purchased by defendant number 3. It is also stated that while passing the impugnate order, this court has ignored the scope of ambit of section 14 of 1 of Hindu Succession Act 1 and accordingly sought for review of the order. It is also stated that petitions that respondent nos 2 and 3 are bona fide purchaser of hereinafter referred to as Act. Their interest has been safeguarded and accordingly the petition has sought for review of the order. I have heard Shri S.P. Shankar, lean senior counsel, appearing on behalf of Shri Harsh Desai for the petitioner in RPN number 100119 and Shri Shivraj P. Mudhol for the petitioner and Shri Sangam S. Kulkarni and Shri V.P. Kulkarni, lean counsel for the respondents. Shri S.P. Shankar, learned senior counsel for the petitioner, invited attention to the court to explanation of 2 Section 6 of the Act and contended that the tender of the scope of the explanation has not been considered by this court and accordingly sought the interference of this court. Referring to XP 34 and D3 of the original records, learned senior counsel for the petitioner argued that the father of the petitioner separated himself from Hindu undivided family by taking the due share in the family properties and therefore explanation. Second, to Section 6 of unamended Hindu Succession Act, applicable to the facts of the case, and therefore sought for the interference of this court on the ground that there is error apparent on the face of the record and the same has been rectified in the review petition. In this regard, to the reference to the judgment of Honorable Supreme Court in the case of Vineet Sharma vs. Rakesh Sharma, reported in AIR 2020, and invited attention to the court to para number 53 and argued that as there is error apparent on the face of the record in the impugnant order inquiring the settlement principles and therefore sought for the interference of this court. Lean senior counsel further argued that the court has committed an error in misreading the plaint averments and has given a finding in the impugned order, which was neither pleaded nor proved in the evidence and therefore sought for review in the impugnant order. It is also submission that leaned senior counsel for the petitioner and that the jurisdiction of the appellate court under Section 96 of CPC is circumcised while considering the pleadings.
Wait. Now, all of you can see the Vinita Sharma's case. Everybody knows that it was a case, landmark case, through which the equal rights to the properties were given to the women also, sisters also, sister and brother equally. Also, there is one important case, Kanhaiya, I'll just, Kunaiya Umid and others versus State of Kerala. This is very important judgment of the Supreme Court. I would request all of you to read this. I will be sharing in chat box also this judgment. So One of the co-hosts can share this link, indiancanon.com, so they will know. These two judgments I would like all of you to read. It will help you to understand actually how the revision or the review goes ahead, and also what points are taken, because it will be actually difficult. Every person as a lawyer will feel that this is actually error apparent on the face, or there is a the order is not legal, there is no correctness of order, or the court has passed an order without jurisdiction. But it will be a different thing. Now, if this concept is cleared, we move the ahead with the legal vocabulary. The first word is conducive. Uh, there are I see students, I have been seeing this, that is learned counsel and impugned order. I've seen everybody is been some other words, pronunciation different, but it is learned counsel and impugned order. Conducive, it is only to correct you, so take it positively. Now, conducive, making it easy, likely for something to happen. The word itself is conducive. So, making it easy. Such a practice, if adopted, would be conducive to judicial discipline. So, it should be conducive situation. Holistic approach. Again, a very big word. Encompassing the whole of a thing. That is mean thinking from all the angles. Treating legal issues by considering the whole person or the entire context of a situation. It is not for the plaintiff or defendant, for the entire thing. Context of a situation rather than just the
Madam,
legal.
voice is not clear, madam. Not audible, madam, please.
Vandana, clear hai?
Clear है.
Okay. Go on the good network, maybe a problem will get resolved. Holistic approach, encompassing the whole of a thing. Hmm? Now, adjudicating authority directed the COC or the interim monitoring committee, that is IMC, to adopt a pragmatic and holistic approach in determining the amount payable to the appellant. Like holistic approach to think from all the angles. Now, next is acrimony, anger and bitterness. Friendship turn into bitter animosity and acrimony due to failure of a sale transaction of a piece of land. Very simple word. But if you use it, normally it is also used in the matrimonial dispute. Next is ensured. To happen after something else or as a result of. At this stage, bitterness and acrimonious between the parties have ensured. Hmm? It has happened at this stage. Normally we speak this in the matrimonial dispute. Now, loggerheads. This is the common word we use in the English language while in daily conversation. Arguing or strongly disagreeing. This court found that the parties were continuously at loggerheads over joint development of certain land. They were arguing, they were going and disagreeing. One is on this side, another in that side. Probity, the highest standard of integrity, honesty, and moral uprightness. Hmm. Now, see, this is the rare word, but to be used will actually give good impression. There is total lack of probity and fair dealing affecting the rights of the shareholders. The affairs of the company are being conducted in illegal, invalid, and wrongful manner. So, there is lack of probity. It is used negatively here. Next is elucidate. To explain something, elucidate. To make it very clear, elucidate. For the purpose of elucidating the facts. See, elucidating the facts. Respect of any matter in dispute means where the circumstances render it expedient in the interest of justice to do so. Next is pragmatic. Practical as a matter of fact and realistic. And many times there is no pragmatic approach. If pragmatic approach is adopted, then this problem can be minimized to a large extent. Paradigm shift, an important change, new approach. Paradigm shift is something, if you sit in the High Court, you will be hearing it. Through this bill, the total medical system is now becoming patient centric. So I would say, as the Honorable Minister in his introductory remarks mentioned, there is a paradigm shift, bigger change, new approach. It is the paradigm shift that instead of becoming doctor centric, an attempt is being made through this bill to make it patient specific. Now here bill means an ordinance or a law to be made. Next is adjudicate. See, if you divide it, adjudicate, that is judging, to pass judgment on as a judge, settle judicially. If the applicant does not disclose full facts or suppresses relevant materials or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. See, it is here also it is used negatively, but what is it saying? That if there is suppression of relevant material facts, guilty of misleading the court, then court will not even hear the matter. It will dismiss without adjudicating, without judging the entire matter. Good words. Thank you to Vishaka and Sangapriya who did it today. Now, next part is the art of drafting. I have written a book. Vandana may have shared in the chat box on the drafting. Those who are first generation lawyer or second generation or anybody will always have a difficulty in drafting the matters, because the drafting is something which has a style of court. It cannot be like writing a letter to the judge. It is not easy. What is taught in the school or college is totally different. Practical approach is different. Now, how do we draft? It is not easy for a junior to copy and paste, or through AI you can always do it, because every case is a different case. Every case is different facts. I can never say in my 27 years practice that this case is actually very, very similar to that. Just copy and paste. No, it is not that easy. Now, how do we improve drafting? How do we do it? Now, the easiest method which I have learned through my seniors and through my friends, that if you get a domestic violence case first time, now as a junior lawyer you may not have the format also. Now format is available everywhere, but what about the facts? You can't write the facts just like that. He has bitten her. No, no, this is not the way to start. There is a way, there is a language, there is a format which you should follow, and the drafting should have the legal words. Why we are doing the legal vocabulary? To use the legal words. If you can't use the legal words, then actually your drafting will be very simple. Now everybody says be simple in your language. Right, you can be simple in your language, but see, we are standing in the court. Now it's a place where if you speak good English, good language, it may be your local language also, it actually impresses the judge. See, what is lawyership? I would say it is the art of persuasion. And how do you persuade somebody? By speaking properly, by speaking in a language which impresses the other side. So drafting is first part which the honorable judge will read in your absence also and in your presence also. Because today you argue the matter, what will happen later on? Judge may note some points, but later on he will go through your brief and paper book, what you have written. So that will impress. If you put your facts properly, it will help. Now suppose you get a domestic violence case or Hindu Marriage Act petition, that is of divorce. Now as a junior, how you will do it? You may get a format. What about the facts and the way it has to be done? First thing I'll tell you, if you are from Karnataka, there are three benches: Dharwad, Kalaburgi, and the Bangalore. Go through last 5 years judgment on divorce. What is the court saying? In that you will find the grounds, you will find the prayers, you will also find the how the facts are written. Trust me, nobody understands this That is all difficulty. If you go through that, trust me, you will find how to write the petition also. This is the art of drafting. Secondly, your legal vocabulary should be very good. And if you read those judgments, you will find that actually you will find the prayers also. Long back, I had got a habeas corpus rate, and I was actually in a difficulty because it was the first time I was doing it. I did not know, and I was unable to get any copy of habeas corpus from any of my friends. Now, what to do? And I was that time at the Supreme Court, and here it was in Bombay High Court. I started reading all the judgments of the last 10 years of the Bombay High Court. And trust me, with that, I could draft the best habeas corpus petition according to my potential. That is also there in my book. And if you read it, trust me, there was not a single objection. Secondly, it without circulation, it was high on the board. If you go to the high court, there are some matters which are kept high on the board, that is of the emergency. So if you draft it properly, you can argue properly. So first part, reading of judgment. Second part, improving your language. If your language is good, it will impress the judge. Now third part of the drafting is the taking the instruction from the client. If you don't take the instruction, you say, no, मैं draft करके डाल दूंगा divorce petition. Don't do that. It is not a cut and paste job. If you do that, it will actually, I won't say, you will be harming the case of the client. Because today the case is with you, and tomorrow the case comes for the evidence purpose, matter is not settled, then all things will come out. Also, there is a possibility that you're ruining your own reputation. Today I have drafted something, it goes to another lawyer later on because of some reason, and that lawyer reads our petition, and what he will think of us? He say, she has not drafted it properly. And more than that, everything, one thing I would always tell you, that every file given to us by the client is his life, which is going to decide his next 5, 10 years, or sometime 20 years of his life. So as a doctor, as a lawyer, it is our duty that we do our best as per our potential. And if you don't know, there are many seniors who will help you. Go to library. And one more important point I will always add to the, go to the books which are of the commentary. Suppose there is Hindu law, there is a mullah's book. Till date, people are referring it. I think more than now, how many years you have to count? It is about a decade now, or it is going to happen now. So they are reading. If you read mullah's book on the Hindu law, you will know there are so many judgments, there are facts. So always read the books which are on commentary. Now commentary books I will not ask you to buy, but one thing you can do, go to the nearest library, any law library, any court, and no court will tell you that you are not a member, we will not allow you. No, they will allow you, but then you have to request. If you sit in library, you will be meeting many learned counsels, learned lawyers who are sitting there, wise people. Plus, you will also have the interaction that what case you are drafting, and people will help you. They'll tell you, अरे मेरे केस में ऐसा हुआ था. नहीं, this is a judge, he wants this kind of prayers. 1, 2, 3, 4, 5. You mention this. You mention this averment. So people are there to help you, but then you need to be among the people. As I was discussing that day, they need to go to the bar room, that is the lawyer's room in the court. It may be smallest court, in Mofizal court. Mofizal means गांव का court, गांव के area में. Or it may be in the town, first tier, two tier city. It may be high court, whichever court is near to, go to the library. And library, there are many books. If you read it, I've gone to Nagpur High Court Library, I've gone to Bombay High Court Library. I've gone to many libraries, and I must say they are so properly managed. Only they are waiting for us to read. Until the court, even if your case is over by 2 o'clock, sit in the library, spend 1 or 2 hours, spend some money on that. You can't buy every book, and reading is something which will actually contribute to your drafting and develop your drafting skills. So drafting is very important. It can't be learned in a day, but you have to keep on reading the judgments. And one thing very I will repeat, always do one thing, that if you are, whichever state you are from Tamil Nadu or Karnataka or Maharashtra, go through the high court judgments of that particular period of last 10 years on that subject. If it is a divorce, if it is a partition suit, it may be a 138 check bouncing matters. So these kind of books will help you. If you just start going to do AI or Google, no, that is not a long term practice. If you want to be a actually a litigation lawyer, you must read the books and the judgments. This was all for today. Thank you so much.
Excuse me, madam, I have a question. Can I go ahead?
Yes, yes, yes.
Okay. Madam, I'm Ravi Sapkal. I'm in second year of JCCL.
Okay.
You covered the topic petitions and drafting. So I have a particular question about petition drafting. This is like, one second, madam. There are two questions in one. There are two parts of the question. One is about the pagination. Like earlier, they were starting pagination from the main petition itself, and they were, the learned lawyers. They were using like Roman alphabets sometimes, and alphabet also, numericals also. So there are four types of things in that. Uh, like. Now the index is the first page that the
I'll tell you.
honorable judge would see.
I got it, Ravi. I will tell you. It is the High Court papers.
Yes,
Or,
it is a petition under 226.
okay. Even it happens in the, I will tell you, sir, in family court matters also. First part is index. Normally, it is sometimes it is not numbered, and then it will be Rojnama in family court matters. In the High Court, there will be some papers or the synopsis,
Right.
list of dates and events.
Right.
Right. They will be in the Roman, and then there 1, 2, 3, 4, 5, 6.
But madam, here one thing is that the judge would see something in the alienation of the page that we will.
No. Judges are very smart. They know. They know how they.
Even it goes.
No. They are aware. That is a regular practice.
Ma'am,
That petition will start from page number 1.
Okay.
Synopsis index will be different.
Okay. Alphabet or Roman?
Yes.
Like that. Okay.
Yes.
And another thing is the body of the main petition. Sometimes I have read some 50-55 petitions from High Court and Supreme Courts before drafting this petition.
Very nice.
Yeah. And some 150 judgments also of different High Courts and lot many from Supreme Courts. So there are when we type the main body of the petition, like it goes like introduction or array of parties, facts, causation, grounds, prayers, and then verification, of course. So now the question is, I have seen the petitions in which sometimes they would use paragraphing, like this is about the scheme of paragraph 1, 2, 3, 4, 5, 6, and sometimes they will use
paragraph. Grounds also ABCD. Prayer will be Roman 1, 2, 3, 4, or the alphabet small I.
Small ABCD.
Yes.
And madam, this thing and facts would be facts, or the cause of action would be 1, 2, 3, 4, or
you are from Maharashtra?
Yes, I am.
Yes.
I'm from
asking the facts. See, there is no such rule, but I normally do 1, then B 2, then ABCD facts. It will be capital ABCD.
Okay.
Ravi, you can check my book in the Bombay High Court Library. It is available. Session code also.
I will order it just now. So it will come as a personal gift to me from you. That's all, man. Thank you. I'm obliged.
Any more questions?
There are no more questions for tonight.
Okay.
Hello, ma'am.
Hello.
Ma'am, my name is Nitin Botwe. I want to ask about tribunal.
Okay.
Is there tribunal practice is okay to start?
Yes, very
Like
you should. See, as day before yesterday or yesterday we read about the trademark cases. It is also a good place to start practice. See, I saw when you first generation, second generation lawyer, when you start, you have no choice but to
first
start.
generation, ma'am.
Which generation?
First.
Yes. So I heard fifth. No. Start with tribunal. It's also a good place. From tribunal, you may get a matrimonial dispute, or you may get a criminal case. That is I would say it's a luck and destiny. You never know where it will take you.
Yes, ma'am. My senior send me to the MAT tribunal regularly, and I am familiar to the other
Which
advocates
tribunal you're
also there.
talking? Which tribunal?
MAT, Mumbai,
Very
Maharashtra
nice.
Administrative
Very nice.
Tribunal.
Very nice. It's a good place to practice.
Okay, ma'am.
Nothing
Thank
is
you,
bad
ma'am.
in the litigation. I'm telling you, litigation practice will give you everything, fame, money, respect, everything, and the knowledge. And best part of it is you can help so many people.
Okay, ma'am. Thank you, ma'am.